Welcome everyone to this week's Long Island Legal. My name is Joe Campolo, Managing Partner of Campolo, Milton, McCormick. This week I have joining us Arthur Yermash. Arthur is a senior associate with the firm, and his practice primarily consists of our labor and employment types of issues. So Arthur, welcome.
Thank you, Joe.
You're welcome.
And thanks for having me on this morning.
Arthur holds a dear spot in my heart because he was the first employee of the firm. When we started it, and still no gray hair. So I guess we're not working you hard enough, Arthur. So labor and employment has become a very large part of the firm's practice, and on a day-to-day basis, you're handling those those matters. But tell our viewers. Our viewers are mostly small businesses that are looking to pick up some strategies for their business. Tell them what types of things you're handling on a day-to-day basis and what they should be looking out for.
Sure. So one of the key things that comes out of representing businesses is that a labor and employment type of practice is very important in making sure that companies and business owners are aware of what regulations they have to follow, what types of rules and different things that they have to do with their employees to make sure, on one hand, that they follow all of their rules and requirements, and on the other hand, to make sure that they're really running their business as efficiently as possible. So one of the things that we do with our labor and employment practice is we help business owners put together their policies, understand what rules they have to follow with respect to paying employees, minimum wage, overtime, all the different things that come with that. And we help them put their employee handbooks, which have a summary of those written policies, and employment agreements, non-compete agreements, and ultimately, if things do break down, we have been doing a lot of work in helping our clients get out of and deal with investigations and ultimately litigation when things can't be resolved in any other way.
Right. So that's a lot. Let's break it down a little bit into smaller pieces. So I know a lot of your time during the day is spent fielding just general phone calls from business owners or human resource officials, right? And so that's how you like to build a relationship with the clients?
Sure. So again, HR compliance, and that's a human resource compliance, is a big part of that. Typical day-to-day questions, come in all the time. Are we paying our employees the right way? What type of vacation policies are we allowed to have? What type of vacation policies can we have? Or are our current policies really complying with the law? Those are just a handful of things that we really answer on a day-to-day basis.
Right. Training, I know a lot of times people come up with questions about, do you have to pay employees for training? Do I have to pay employees for lunch? How much vacation time do I have to give? All of those types of issues.
Right. And one thing that we get pretty consistently is vacation time and benefits, right? So employers rather always want to know, what do we have to give our employees? What do we, or how do we structure our benefits policy? And benefits include things like paid time off. Benefits can include things like health care, insurance, disability insurance, stuff like that. And one of the things we tell a lot of our clients is those types of policies and employee benefits are really at the discretion of the business owner and the company. There's no really minimum requirement. There's no right way or wrong way to do it. But the goal is always to make sure that the policies are consistent and that they're written so that everyone understands what the policy truly is, and there are less questions from employees, and that way the managers can focus on managing the work instead of constantly fielding those types of questions. So,
right. So this is an interesting point, I think, for our viewers to understand, because it's something I didn't know until I actually started running a business, and that is, you're really not required to give anybody any sort of paid time off. Sick time, vacation time, no legal requirement for that. The legal requirement is you just got to pay people for the hours they've worked, correct?
Right, that's absolutely right. And
so it's a business decision to make your business more attractive or competitive with other businesses as to what sort of policies you have.
Right, so that's exactly right. It's really up to the business owner to say, you know what, everyone gets 2 weeks time off. that's paid, and that's our policy. 3 weeks, 4 weeks. It's really up to the business owner to structure that, as long as they apply that consistently to all similar employees. Now, I do want to make one point on that, actually, and the law seems to be changing a little bit in that area. New York City, which is really the 5 boroughs, passed a law earlier this year in April of 2014, saying that all employees are entitled to 5 paid sick days, right? So this is a big change in that regard. Now, it's unclear whether that change will expand outside of New York City, whether New York State will pick something like that up and have that requirement for the entire state. But right now, for anyone doing business in New York City, that is the new law and the new requirement, that everyone gets 5 paid.
Full-time employees, right?
It applies to full-time and part-time, so it's really across the board.
So part-time employees get paid time off as well.
Correct, and so the way business owners get to control that is they're allowed to accrue it over the year. It's not something that is, January 1 everyone gets 5 sick days.
Right.
It accrues over the time of the year, but it is a change in policies now. A lot of employers already have policies that are consistent with that requirement, where they do have paid time off and paid sick time for their full-time employees. As you mentioned, part-time employees often don't get that type of benefit, but with this new law for New York City, it really applies across the board to all employees.
Right. Let's talk a little bit about unpaid overtime. Okay, so seems to be a lot of cases going on with regards to unpaid overtime. So what is, so our viewers understand the general rule. What is the general rule as to who is entitled to overtime and who isn't?
Right, so the general rule is that all employees that work over 40 hours in any given week, and again, it's measured on a weekly basis, are entitled to overtime, and overtime is measured at time and a half for every hour over 40 on a weekly basis. There are exemptions to that general requirement, as there are with a lot of laws and regulations, and the exemptions really vary. There are, probably over a dozen different exemptions, all applying to different types of employees. Some of the more common ones are you have a professional exemption, right? So you have lawyers, doctors, those types of professionals are exempt from overtime, so the employers can have them work hours as needed to complete their task and their job responsibilities. There's also a managerial exemption. The managerial exemption applies to actual managers who manage the business, who have hire and fire abilities and opportunities to do that, and they have to manage at least 2 employees that answer to them. So those are just the more common ones. There are, again, as I mentioned, over a dozen different exemptions that do apply, and they're really applied on a case-by-case basis.
Right, so just so our viewers are clear, if an employee is not in one of those exempt categories, right, and you have them working 50 hours a week, let's say, and you pay them a salary, let's say you pay them $1,000 for that 50 hours, that's not right. The Department of Labor is going to take a position that you're not paying them correctly. Is that a fair statement?
Right, that's absolutely right. What the Department of Labor looks at is even at a salaried employee is entitled to overtime if they're working over 40 hours and they're not within one of the exemptions. So what that means is, and what the Department of Labor often does to handle a claim that an employee may bring, is to take that $1,000 divided by the 50 hours that the employee worked to get what's called a base rate. That is that employee's base rate for their hourly work that they do. And then they calculate the difference between 40 hours that they that are not subject to overtime and the extra 10 hours that they work above that. And it really, often they take the position that the employee should have been paid time and a half of that base rate above the 40.
Right, and then there's penalties and all other sorts of things that go on in the event that an audit is completed and found that people are not paying their employees correct.
Right. So exactly right, and we've handled a substantial amount of these types of audits and investigations. What typically happens in that situation is often an employee either files a claim with the Department of Labor. Sometimes the claims come from all different sorts of areas. Sometimes a competitor may recognize that the business is paying less than they should under the law, and they want the Department of Labor
paying
to
cash,
investigate.
right?
Exactly right. Or cash is another.
So competitors file a lot of complaints.
Right, exactly right. I mean, people think it's always a disgruntled employee. We've seen where competitors have also filed that claims, and the way the Department of Labor typically operates is they're obligated to investigate every claim. So regardless of the source, they investigate. They would want to look at records. They want to look at talk to different employees, stuff like that. One of the things that often happen that catches a lot of employers off guard actually is on-site spontaneous audits. And what happens is
just to stop there, because people should understand that the Department of Labor, under the statute, does not need a warrant to come in and perform an audit on the premises. Is that correct?
Yes, that's right. The Department of Labor really has very broad rights and investigative powers to perform their job, which is to enforce the labor, wage, and overtime laws. So yeah, I mean, on a complaint, they can do things like perform an investigation. They've actually done surveillance where they camp out outside of businesses for days, different times of the night if it's a 24-hour business, and and then obviously, as I mentioned, they could just show up at the business and request records right there on the spot, request to talk to employees, and that happens all the time.
Yeah, talk to investigators that are auditing like pizza places, and they'll actually sit and count the pizza boxes that are moving through the store in order to see how much they're actually making in case there's cash issues. State Department of Taxation and Finance does that. I mean, investigators have very, very broad powers. So what should a business owner do if the Department of Labor shows up at their office? What do you suggest they do for one of these audits?
Well, there are several things that business owners can do to really protect themselves and put them in a better position to respond and handle such an audit. One thing is the manager that's on site should always be aware and have certain things in mind in case something like this does come up. One is who should that manager contact. Obviously, if the manager is not the business owner should be contacted. If there's a legal representative that the company works with, that person should be contacted as well. While they can't just turn away the investigators. That would be unlawful. What you can do is walk the investigators through the site as they ask to see different things. You can ask to be present in certain employee interviews that they may want to do on the spot. Now, they don't have to grant you the ability to be there, but at least you can try to do that. You should really also, as a manager, take notes and really get a sense of what the purpose of the investigation is, right? Sometimes it's from a former employee, sometimes it's from a current employee. Now, I wouldn't recommend directly asking them right there on the spot in the initial investigation and in the initial audit as to why they're there. But you could probably pick it up from some of the things that they're doing. The other thing is, they may ask for records, and often what happens is, while it's great to be courteous, and we definitely recommend being courteous and helpful to the investigators, it's not unfair and unreasonable to ask for time to be able to produce people, to produce records, stuff like that. And we've seen a lot of investigators, even though they show up, and show force and really show that they're taking an investigation seriously. They're often very helpful, and they do give more time, and so that gives the business time to prepare what they need to be able to present it in an efficient manner.
Right. So really, the first thing business owners should do if the Department of Labor shows up at their doorstep is call you, Arthur Yermash, Senior Associate at Campolo, Middleton, and McCormick. So thanks, Arthur. That was really helpful information. I'm glad you got a chance to join us.
Great.
And thanks everyone for watching. Have a great week, and we'll see you next week.